I now would like to introduce Marisol Collazo. Marisol is the board chair of the group called Women's in Derivatives, or WIND. She is head of management relationships at DTCC. But most importantly, and the only thing on her resume that really counts, she's an alumna of New York Law School, class of 2002.
Thanks, Ron, and thanks to New York Law School for co-hosting this event with Women in Derivatives. And what a pleasure it is to come back and see a new building and all these additional spaces. I have been back once before since the building, but it brings fond memories. So I don't want to defer too long because you're going to hear from a fabulous panel, but I did want to, before introducing them, share a little bit about WIND and who we are and how you can engage. So first, to start off with, WIND was established in 2007. It was established by a group of women who saw that there was an absence of women in their networking circles, in their business dealings, or in the industry. In fact, one of them is sitting right there, Angie, Karna. And so this was a great way in which we were able to get women together at conferences and speak on education topics and really bring women together. Fast forward today, we have over 6,000 members globally. And this is a real pride point for us in the US, spanning beyond New York into the West Coast and even in Atlanta, as well as Chicago. And then we also have, locations in London and Singapore as well. So all of this happens through a couple of ways. One is we have a very diverse board representing 16 senior women in the financial services, ranging from roles like lawyers, market infrastructure, such as myself, fintech, regulatory, you name it, both on the board member level as well as advisory, which is for our signature sort of senior leaders who either cannot serve time on the board or can just help in terms of influencing. Our mission is specifically to attract, retain, and educate women in financial services. And we really have broadened that even beyond derivatives because after all, we work in multiple markets. And so want to share just a little bit about how you can engage. We have programs that attract all, both men and women. We have fantastic education events like these in person, but also virtual. We were able to pivot during the pandemic, and we've realized that it's an audience that continues to be very interested. So just recently for Women's History Month, we had 4 weeks of a lunch and learn where you could come in, you can listen to a business topic, you can hear about professional development. It really is open to all. So, education for us is the backbone of what we do and we want to continue to do, as well as connecting women in the industry. Second, we also have a rolling admissions for what we call wolf packs. So it's a way for women at any stage in your career to reach out to WIND, and you can do so by going to our website, www.womenderivatives.org, or by following us on LinkedIn. And by joining a wolf pack, it's a great peer networking circle. It connects you with the WIND leadership, and it's a way to engage. If you are on the corporate side, we also have great corporate sponsorship programs, and I encourage you to follow up with me after during the cocktail events. This is a great way for corporate sponsors to engage with WIND as we partner with executive coaches, and we offer leadership development courses that are highly curated through our board members and are offered for a year-long program. So do look for me. And we also offer leadership opportunities for women who engage with WIND. We call it our ambassadors program. It's a way for them to engage with our content to help us deliver our programming and a way to be connected and basically elevated in their skills. So that's a lot said. Please do, if you're interested, connect with me during the break. And without further ado, I want to introduce our panel, our very esteemed panel, I should say. Deborah, I'm going to just turn over to you. If you can introduce the rest of the panel.
Oh,
Thanks.
that's great. Thank you so much. Thank you for joining us. Thank you for supporting New York Law School, and thank you for especially coming out to support WIND. I must say I have made it very easy for you because I have an amazing panel, and we perhaps won't talk about conversations with former presidents or even current presidents, but we will talk about some very exciting things about how we all spent the past few weekends together. So I should say it's a real privilege to speak after two real giants of the industry. So thank you for your comments, Leo, and thank you for inviting us here, Ron. So I should let you know that I know we've got an audience of some real veterans. We've got regulators and industry experts, and then we have some students. And I do want to say, to echo something that Marisol said, which is do help each other out and support each other, because I'm here actually thanks to Angie, who when I arrived in the shores of the United States over a decade ago now, Angie really helped me get to know the industry. And so first, we're going to talk about an overview of the different financial institution insolvency regimes. In the US, it's quite complicated. There's different situations depending on what entity you're facing. It may not be entirely straightforward, or you may need to consider what the actual regulatory regime is that's going to be relevant in a distress scenario. We're going to talk about the basics of FDIA proceedings. We'll talk about QFC closeouts, credit default swaps, and of course, we'll talk about a case study, which is Silicon Valley Bank and Signature Bank. And we will explain all of these acronyms as we go. The way we're going to do it is we're going to have Brandon give us an outline of the law and the regulation, and then I will ask Sachiyo and Angie a few questions to really bring out how that all works in practice. So I'm going to turn now, I think, to the slide that's going to give us an overview of the different financial institution insolvency regimes that could be relevant as you see a bank leading its way into distress.
Thank you. So as Deborah mentioned, banks, most broker-dealers, many financial institutions are not eligible for proceedings under the bankruptcy code, nor are they subject to one single type of special proceeding for financial institutions. Rather, each type of financial institution, and sometimes there are different regimes that apply to a single type of entity, is subject to a different type of regime, which creates quite the alphabet soup, as we've shown it up here. Some of these regimes are entirely independent of the bankruptcy code, like the Federal Deposit Insurance Act has no real relation to the bankruptcy code. Others try to leverage the provisions of the bankruptcy code, either by incorporating them by reference or actually being under a special subchapter of the bankruptcy code. As we consider these regimes, we think there's two principal types of risk to bear in mind when you're facing an institution. First is custodial risk. The first is custodial risk. So I put my money at a bank. I put my securities at a broker-dealer. I clear futures contracts or cleared swaps through a futures commission merchant. What is the risk that I actually get those assets back that I'm holding through this institution? That's custodial risk. When you're thinking about those risks, always need to think about what the type of entity you're dealing with, as well as what type of assets you put with that entity, as well as what that entity is allowed to do with those assets. Then there is counterparty risk. Counterparty risk is essentially I'm entering into a trade, a swap, a repurchase agreement with a counterparty. If that counterparty becomes bankrupt or defaults, I want to be able to terminate that trade, liquidate the collateral I might be sitting on, net amounts owing. And will the insolvency regime that applies let me do that or impose stays or other mechanisms to interfere with my ability to do that? These two risks are very critical, and it's important to keep them apart and separate while we think about these institutions.
So before we go on, Brandon, let me just pause here and ask Angie and Sachiyo. So you see a financial institution teetering, things are not looking great. Obviously, your job is to protect your institution. Which of these risks do you worry about more? What are the first sort of things that you do, and who is on your speed dial? Hopefully Brandon, but what are you thinking about? Where do I need to, how do I need to manage the limited time I might have to start dealing with this crisis?
Yeah, so yes, definitely. We have Brandon on speed dial, but I would say both risks are very important. As an asset manager, I think we do focus a lot on the custodial risk. All of the assets that we manage are not custodied by BlackRock. They're held at a custodian by the fund's choice, or of the fund's choice, or of the client's choice. And we do think that the insolvency regimes generally protect those assets, and we should get them back. I think the critical thing to know is in what capacity is the financial institution holding your assets for your clients? Are they a bailee? Are they a custodian? Or are they a counterparty? And also knowing the limits of the protections available to your customers under the applicable regulatory regime, so that if you're holding cash, for example, you need to keep it within the depository limits that protect you. Overall, though, as it relates to custodial risk, absent fraud, we should get the assets back, and it would be catastrophic if we didn't get them back. On the counterparty side, we do spend a lot of time thinking about what the different legal entities are, the different insolvency regimes that apply. Who are you facing? Are you facing a U.S. broker? Are you facing the Irish subsidiary of a foreign bank? Are you facing a New York branch of a foreign bank? And all of those different entities or branches have a different regulatory insolvency regime that you need to pay attention to. The last thing is, do you have a QFC or a non-QFC? And you need to think about whether the trade that your clients, your traders are entering into are sort of on the outer sort of periphery potentially of a QFC. And if it is it going to be recharacterized? You thought you had a loan, or do you have a secured a swap instead of a secured loan? That could mean a huge difference in your recovery and the timing with which you get your assets back.
Angie.
Yeah, so Deborah, as Sachiyo mentioned, there are two kinds of risk. We, as a Southside institution, however, don't focus as much on custodial risk. That may come up perhaps if we have some pledged margin somewhere, for example, that is not segregated. But in general, we really focus on counterparty risk. And of course, Brandon is on our speed dial. I realize I need to do a conflict check to make sure that Sachiyo doesn't have them secured first. But besides having external advisors on our speed dial, really internally, we have default management protocols, processes, so legal, credit risk management, operations, market risk, front office risk. As soon as there are signs that something is amiss, and those signs can come from multiple places. They can come from a rumor in the market. They can come from a client saying something directly to a salesperson. They can come from a margin call being missed. They can come from settlement not being made. All of these things can start, frankly, a frenzy of activity in a well-organized Southside institution where people are gathering around, and the lawyers in particular are working very closely with the credit risk people typically to look at what our contractual rights are at that point in time, and are there any regulatory regimes, whether it's insolvency or otherwise, that we need to take into consideration.
Thank you. I mean, one of the things I've noticed is how, over time, I started practicing law, well, not in 1974, but well before the financial crisis in 2008. And firms are very organized, I think, internally. That's what we see from the outside. So by the time you call us, people have a very good handle about what's going on with their documentation and their teams. So it's obviously good news and heartening. Okay, so moving on. Wait, this was always going to be bad, leaving me in charge of the liquor. So key considerations for customers and counterparties. Brandon.
So as we talked about, there is a different regime that applies depending on the entity that you're facing. So the first question you want to answer is, okay, let me pull out the docs. What entity am I facing? And if you ask someone and they say, oh, it's Lehman Brothers, period, That's not the answer. You actually have to see what is the legal entity. Oftentimes that will be followed by a suffix, an NA, National Association, an LLC, an LLP, something of that sort. So once you figured out what that entity is, you have to figure out what insolvency regime applies. If it's an FDIC insured bank, that's the Federal Deposit Insurance Act. If it's a US broker-dealer, then most of the time, not always, but the vast majority of the time, the relevant regime is the Securities Investor Protection Act. If it's a futures commission merchant, then the relevant regime is going to be the CFTC's Part 190 rules, as well as Subchapter 4 of Chapter 7 of the Bankruptcy Code. Just pause there for 1 second. In many instances, if you're facing a broker-dealer, that entity is also duly registered as a futures commission merchant, which means you will be subject to both regimes, both the Securities Investor Protection Act and the Part 190 rules, to the extent they are incorporated by reference into the Securities Investor Protection Act. And so you have to think, okay, I'm facing this broker-dealer FCM. What side of it am I facing? Am I facing it in relation to futures? Am I facing it in relation to cleared swaps? Or am I facing it in relation to my securities positions? Or do I just have a regular old repo or other trade with them? And you have to look at both regimes in terms of assessing those risks. Then you get to the bottom of this table and we start talking about branches. So if you're facing, as folks probably know, banks are unique entities in that they can have a home office in, let's say, France, in England, as well as a branch in the United States. And when you have that type of situation, you have to consider two regimes. First, you have to think, okay, in their home jurisdiction, what is the insolvency regime that governs? And for England, I think I see my colleague Ferdisha Snag back there. You would ask her how that works. But then you say, okay, that's what England will do. What will happen in the United States? You have to figure out what type of branch they have here and who charters it. If it's a branch chartered by the New York Department of Financial Services, which is most of the time going to be the case, then the relevant regime is the New York banking law and the DFS's ring fence abilities under the New York banking law. If it's a branch chartered by the federal government, by the OCC, then the relevant regime is the International Banking Act, which has actually never been applied to a federal branch to date. In addition, you're going to want to think, okay, that's New York, that's the federal situation. Do they have a California branch? Do they have a Florida branch? Do they have a Connecticut branch? And look at those regimes as well. And then if you have a regular old corporate, maybe it's a swap dealer that's not a bank or a broker dealer, then it's a lot simpler. You just go under the regular old bankruptcy code. So there's a lot of different regimes to have a lot of fun with.
Okay, so clearly, Sachiyo and Angie, your jobs are easy because it's, just a few things to think about. But maybe taking a step back before you get into the distress scenario, when you're looking to deal with a large financial institution as a counterparty or as a client, as the case may be, what do you really think about? I mean, do you go in your mind, you go through these regimes and say, okay, if I deal with them, this is the risk? Or how do you think about that?
Yeah, so what Brandon went through just now is exactly the sort of speech that you go through with your in-house clients when you start treating with somebody. You literally need to be able to just have it roll off your tongue like it did with Brandon. So you look at the insolvency regimes at the time of onboarding of the trading counterparty. You read the trading agreement netting opinions that are available to you. There are often suggested changes to your contract in those opinions that you want to incorporate. And really, by the time you get to time of stress, it's too late to be learning about them. You need to be intimately familiar with them, and you need to have the documentation ready. Things like the affidavit that you would need to submit for a broker-dealer bankruptcy under SIPA, all those things really need to be well understood and prepared when you're starting the trading relationship with a counterparty.
Yeah, I think I completely agree. And I think it's important to keep in mind that most of the volume of trading activity that's happening in these markets is happening under master agreements. And so it's not one trade at a time. You're setting up master agreements And those are in place often for decades. So when you're first setting up that agreement, that's when you really need to think about, okay, how am I going to be able to net exposures? Am I going to be able to net exposures under this agreement? And that's why those netting opinions that Sachiyo mentioned are so important. The other thing that may apply to these types of counterparties that are covered by these regimes, they may have other regulatory requirements that we investigate at the time of onboarding a client, and that may feed into the documentation as well. But bottom line, it's really all part of the mindset when you're onboarding a client and setting up those master documents. But keep in mind that, when something hits the fan, those documents may be 20 years old.
And maybe just a little bit of more of an operational question, actually, because presumably the two of you are not directly involved in every document, every trade that gets entered into. But when the stress time comes, that's when people are going to call you and you're going to have to answer all those questions. And how do you manage that?
With help. No, but people, there are protocols, as I mentioned earlier. So as soon as a client is in distress, the legal team of any major financial institution has to be in the room. And people should not make assumptions as to what's going to happen, especially if one of these regulatory regimes ends up coming into play. So that's when the internal legal people are important, not just for analyzing the contractual rights, but also for saying, hold on, we don't know what the FDIC is going to do, for example. So we better take a pause, take a breath, call Brandon, or get our expertise some other way. So basically you cannot pre-game everything. You just need to make sure you have the right people in the room at the time.
Yeah, absolutely. And the only other thing I'll say is that as a lawyer, if you are going to be a relevant advisor to your business, you need to be prepared. You need to anticipate the questions that are going to come from your business people. You need to understand what is most important to them so that you can prioritize what your team is going to review, because there are going to be 100 potential questions that you're going to get. And so you're going to have to quickly decide, okay, what's top priority? What am I going to focus on? And what do I need to arm my team with, as well as the general counsel, et cetera, above you, to make sure that they can be helpful to the business.
So let's move on. I think I mentioned the FDIA. I promised you that we would explain what it is. It's been mentioned by Angie. Brandon,
Sure.
and why do we care?
So as we talked about, the FDIA governs the resolution of FDIC insured banks. That includes federally chartered banks as well as state chartered banks that are FDIC insured. So how does it work? Folks who have taken bankruptcy or just generally familiar with bankruptcy know that in a bankruptcy code proceeding, it's a long, deliberative process. Everybody gets a say. Everyone goes into the courtroom. No decisions are made without there being a lot of care and consideration. The FDIA is very different from that, very much by design. Instead, it's a rapid resolution and liquidation process. The FDIC gets appointed, they come in, and they try to find a solution very quickly. Normally, what they will try to do is they will try to transfer the good parts of the bank, the insured deposits, sometimes the uninsured deposits, to an acquiring institution, as well as a number of assets of the institution to that acquiring institution. That way preserves continuity for depositors, preserves the operations, limits the stress on the rest of the system. If that isn't available, they have some fallbacks. One fallback is they create a bridge, and that's actually what we saw in the second step of SVB, where they said, okay, there's value here. We don't want to just liquidate this thing. We can't find an acquirer on day one. Let's create a bridge institution, which is a federally chartered, FDIC chartered, or it's actually OCC chartered, but federally created institution that just continues to operate the bank for a short period of time. While we do that, we'll start marketing the bank and its assets, and we'll find a buyer and we'll preserve value, we'll preserve continuity. And that's what they did. They found First Citizens, they sold the bridge to First Citizens, and then they were able to salvage some value. That sometimes isn't the approach. Maybe they think the bank is just a total mess, and all they can do is preserve continuity for the insured depositors. And what they do there is they often create something called a DINB, which is a great acronym. It's a Deposit Insurance National Bank. It is basically a bank whose sole purpose in life is to help insured depositors get their money back. That's actually what the FDIC was going to do with SVB on the Friday that they took them over. They only changed course when everyone was like, if you follow this approach, it's going to be actually awful. Please use your systemic authority, systemic exception authority to change course. But that is still an approach that the FDIC could follow in a certain instance. And then very, very rarely, this basically never happens. What they could do is if the bank is a total mess, they'll take the bank's assets, they'll sell those assets, they'll resolve all the claims, and they'll mail everybody who has an insured deposit a check. But that I think has happened 3 or 4 times in the modern era.
Actually, Brandon, I'm going to just pause here for 1 second, ask you a question. So you mentioned the systemic important sort of get out, if you like. Can you explain how, because obviously that is exactly what the FDIC used. Can you explain a little bit about how that worked in this case?
Sure. So by way of background, the FDIC is charged by Congress with limiting the cost of a resolution to the deposit insurance fund. The FDIC is an insurer. They collect premiums essentially from banks. Those premiums are used to satisfy insurance claims. When the FDIC takes over a bank, they can't do whatever they want. They have to follow the approach that will result in the least cost to the DIF. And when the FDIC took over SVB, they're basically like, look, we can't cover all these uninsured depositors without following an approach that violates our statutory mandate. I didn't have these conversations with the FDIC. It's just an assumption of how they were probably thinking. However, there is an exception in the statute that says that if supermajorities of the Federal Reserve and the FDIC boards recommend to the Secretary of the Treasury, and the Secretary of the Treasury, in consultation with the President, determines that following this least cost approach will result in systemic risk, then the FDIC can depart from that course and do what it ultimately did in SVB in terms of opening the deposit insurance fund to be able to satisfy more obligations than just what's insured. So that is most likely why we saw a change of course. Was the FDIC said on day one, oh, we can't cover anything. There's not that much value to preserve here. Let's just create this deposit insurance national bank, pay out insured depositors, uninsured depositors, you're stuck, have fun. And then the FDIC decides, actually, with the regulator says, okay, we can't do that. Let's create a bridge bank, protect all these uninsured deposits, and preserve value for everyone.
Thank you. So at that point, if you were facing the bridge, you were facing some pretty good credit.
Yeah, yes, if you were facing a US branch of the bridge, if you were facing a Cayman branch of the bridge, you were not protected because the FDIC doesn't think of those as deposits, which was sad for some clients.
Okay, we're going to move on to the next slide because Brandon has much too much fun talking about branches. So we are going to step into the next bit of the alphabet soup, which also isn't a given. And there's also a bit of optionality, or quite a bit of optionality there, but one of the gifts of Dodd-Frank.
Yes. So after Lehman's failure and the massive systemic disruption it caused, the legislatures, private industry got together and said, this doesn't work. We can't put a big institution into bankruptcy like this and just see the chips fall where they may. We have to figure out an alternative. And the alternative they came up with is something called the Orderly Liquidation Authority, technically Title II of the Dodd-Frank Act. And actually, it resembles very, very closely the Federal Deposit Insurance Act. Indeed, the FDIC will be the receiver of the institution. The FDIC is given very broad powers, can act very quickly. And the goal is to allow some sort of solution to occur quickly instead of having a dragged out process that leads to uncertainty, closeouts, and further loss. The thing is, though, this regime does not apply automatically. Instead, you need to turn the 3 keys, as we call them. Those 3 keys are actually the same 3 mechanisms that apply for the systemic risk exception. In particular, you need supermajorities of both the Federal Reserve Board and the FDIC, or in certain cases, another regulator, to recommend to the Treasury to commence OLA proceedings. And then the Treasury has to make that decision in consultation with the President. And if they do that, then you're into this brand new regime that's never been tried, and that is designed to facilitate a quick, rapid, and least disruptive orderly resolution of the institution. Now, on the next slide, we'll talk about, well, how do they do that? That's great. We have the FDIC. There's no FDIC insurance for the entity. How are you going to make this work? And it's the strategy that folks have developed is something called single point of entry. And we put up here a kind of diagram of what a very simplified bank holding company will look like. And you see the top holdco at the top, and then you have a regional holding company, a regional bank, a broker dealer, another bank. Maybe you have a swap dealer. Maybe you have a futures commission merchant under there. The idea with OLA, the goal is to say this holding company, we'll put that holding company into proceedings. We'll use OLA to essentially transfer all of these subsidiaries, as well as all of the good assets of the holding company, to a new, clean, healthy entity. And we won't touch the subs. The subs will continue operating. Customers will be able to continue trading, getting their money out, buying securities, selling securities, what have you. And all that will happen is that the debt at the holding company will be written down, and those creditors will suffer losses, but there will be no systemic problems. And this sounds wonderful. Indeed, it sounds like it'll work great. We haven't seen it play out that way yet. So there is still a fair bit of skepticism as to whether this regime will actually work, but that's the goal.
So I think there's sort of three takeaways, I think, that are firmly embedded in the sort of outcome from the financial crisis. One is, we want to avoid the mess, the chaos that we had in 2008. We don't want taxpayers to bail out large financial institutions. And we don't want it to get to that point where there's not time for the regulators to come in and resolve these institutions. So, some of these resolution plans that are core to all this are obviously public. Other parts are not for the financial institutions. So, as you're looking at all this, do you crack open the public parts of the resolution plan and see what might happen? Sachiyo, over to you.
So yes, so this is part of the diligence that we do when you start trading with the entity. You definitely look at the public section of the living will and understand it. As Brandon said, if it works as intended, this is great. As someone who lived through the 2007, 2008 financial crisis, where everything cross defaulted and, you were up night after night pouring through the documents and closing people out. This is, if it goes as planned, this is great. It's something that you understand, but it hasn't been tested.
So I have a little PTSD from 2008 since I was at Lehman Brothers at the time. So resolution strategy, is certainly something that our credit department will focus on. But I'll just go back to the practical reality is most of our relationships have been established ages ago. So I'm sure the credit department is cracking open the resolution strategy periodically as part of their overall credit review of different clients, but it's not coming into play when we are putting on trading relationships, because again, most of the major trading relationships have been set up a long time ago.
And I would also note SVB had a resolution plan, and I haven't reviewed it, but I'm quite certain it did not provide for a systemic risk exception. So good, it's a great tool to figure out how the entity is structured, but do not rely upon those plans.
And many lawyers so spend a lot of time writing those plans. But anyway, moving on. Sorry, Angie, go ahead.
But that's honestly, that's a very good point. I mean, there's a lot more transparency, but it's theoretical transparency.
Yeah.
So moving on to the bankruptcy code. You already mentioned that, Brandon. Obviously, the bankruptcy code, says what it says, does what it says on the tin, I guess, or maybe it doesn't. Also, the special innovative products that Leah was talking about, they get special treatment under the bankruptcy code. So do you want to tell us a little bit about that?
Sure. So the bankruptcy code, as folks know, is a court-administered process. It is not some regulator gets large power and authority. Instead, you have an entity, they generally go into liquidation or reorganization. They are the debtor in possession, and they can petition the court for various types of relief. And ultimately, the goal is after a year or 2 years, 13 years, they write down a lot of the debt, cancel the equity, and reorganize and come out an operating thing. And so that is the basic of the bankruptcy code. However, as we talked about, for broker dealers and futures commission merchants, they are subject to regimes that largely rely on the bankruptcy code. The first of those is the Securities Investor Protection Act. That applies to, as we said, almost all broker dealers. If it's a broker dealer where you're holding securities, that's the type of entity that it applies to. SIPC is basically the analog to the FDIC for securities, the Securities Investor Protection Corporation. And when a broker dealer is failing, they can petition a court to issue a protective order that operates very similarly to the automatic stay under the bankruptcy code. It says you can't close out, you can't terminate these contracts, everybody sit on your hands and wait. Then once that happens, SIPC will appoint a trustee for the institution. That trustee will try to rapidly do a bulk transfer of the securities positions of the institution to a transferee. The goal there is, okay, I'm a securities customer of a broker dealer. I want to be able to buy and sell my Google shares, my Apple shares, my Tesla shares. But if this institution is now in proceedings, I've got a problem. I'm state. And so what SIPC will do is they'll try to port my relationship from that failed broker dealer to someone else so I can preserve continuity and keep trading. If that doesn't work, let's say the broker dealer actually doesn't have enough securities to satisfy all customer claims, they don't have enough cash to satisfy all customer claims, the trustee then will essentially liquidate the assets of the institution and provide distributions to customers. Those distributions will be, customers are given priority with respect to those distributions to the extent they constitute customer property. And that serves as some degree of protection to customers, but there's no guarantee that customers will recover fully in those situations. Then let's say I have two relationships with this broker dealer. I hold my Google shares, my Apple shares, my Tesla shares, and I clear my futures contracts, my boring old agriculture, my fancier cleared swaps transactions with them. For those transactions, they're subject to a very similar regime, but a different regime, one administered by the CFTC rather than the Securities Investor Protection Corporation. That regime is colloquially referred to as Part 190, which is technically subchapter 4 of the Bankruptcy Code, which the CFTC can elaborate on through their Part 190 rules. And that regime functions similarly. Essentially, when the institution goes down, the trustee who's appointed, who will be the SIPC trustee, will be tasked with moving all of the futures contracts, all of the cleared swaps at the institution to a transferee. If they can do that, wonderful. Then now I can clear my futures contracts, my cleared swaps at this other institution. If they can't do that, they will liquidate those trades and the other assets of the institution and give me a distribution out of what's called the Part 190 customer property. Now, if your question is, wow, that sounds like two different sets of customer property, is there overlap and controversy as to which one goes to which customers? The short answer to that is, in theory, yes, but thankfully we've never had to deal with that overlap, but that could be a fun issue for some lawyers one day to have to grapple with.
So before you get overexcited about that one, let's just pause briefly. When I started practicing law, I'm a derivatives lawyer, it was all bilateral. I did not know what clearing was. Ron can attest to that. When I was asked to put in place the infrastructure for cleared derivatives, I didn't know what that was and why would you want to do that? So one of the big changes, if you like, from the past financial crisis to where we are today is that there is all this clearing infrastructure and people clear their derivatives, in addition, a lot of their standardized derivatives, because either they have to or they want to, and as well as their futures. So how has that sort of changed the landscape?
Sure. So I would probably say that in terms of these issues, you go from a situation where you had counterparty risk, as we talked about, where you're worried about generally the extent to which this counterparty, this swap counterparty that you're facing, what will they be able to perform, to a question of custodial risk. Your counterparty for a clear trade is the derivatives clearing organization, if it's a future or a cleared swap. Hopefully the DCO will be okay. It's possible it could default as well, but hopefully the DCO will be okay. The key question is, if my broker-dealer FCM defaults, are the futures that they're holding for me, for lack of a better term, that they're carrying for me, am I going to get the value of those back, or has the futures commission merchant done something wrong with those? Have they misappropriated my assets? Have they invested my assets in a way that has caused investment losses such that I don't get that value back? So I think the main way to look at it is you're shifted from that old counterparty risk to custodial risk, except that you still have counterparty risk with respect to the clearing organization. And while we all love clearing at the bottom of our hearts, it is possible, of course, that a clearing organization could default and become insolvent, and that would be a very unknown as to how that will play out in a pretty cataclysmic event as well.
So we talked about the different regimes, we talked about clearing, anything that sort of you want to add in terms of where your priorities are, what comes up for you most, and how has sort of clearing changed the landscape in terms of what you worry about?
So from my perspective, again, because we're a sell side institution and we actually don't have a major clearing business, we're primarily acting in an execution capacity with respect to cleared swaps. So frankly, Brandon's first point is the main one. Between this, where we are in 2023 versus 2008, I have a lot less potential counterparty exposure than I did back then, because a lot of that is now in clearinghouses. I will say, though, we do spend time thinking, and as an executing broker of cleared derivatives, our exposure from a bilateral perspective is a matter of seconds to minutes if something goes wrong. So we don't normally have credit departments setting limits for, 50-second type of exposures. However, our credit department is very focused now on potential risks of facing the clearinghouses in a way that we weren't as focused on in 2008, because that's a much bigger source of risk. So we have limits to certain clearinghouses. We will take a close look at how their default fund works. When something goes awry in the markets, we will take a look at their margin methodology. We do worry that if a large enough institution goes down and it is a large enough part of a particular clearinghouse, that there could be loss mutualization that impacts us. So that's where I would say on the cleared space, our risk focus has shifted more, given who we are in the markets, to the clearinghouse than to the counterparty.
Yeah, I would agree with that. The exposure, I guess, has gone down significantly in the sense that most of our exposure in the swap space is now concentrated, though, in the CCPs. As Angie said, yes, there's a lot of focus on understanding the default management processes of clearinghouses. And you are starting to see more asset classes being cleared beyond just derivatives, and understanding how those clearing offerings differ from sort of your standard derivative clearing offerings is one of the things that I think a lot of lawyers are focused on. And many of you may know that there is a Treasury clearing proposal out there, and DTCC is the only clearinghouse that offers that service at the moment. And it's interesting how the SEC has sought to regulate or mandate rather clearing through the rules of a clearinghouse. So, clearing in general is something that I think lawyers more and more are spending more time understanding.
Thank you. So moving on, let's touch briefly on the New York banking law and then the International Banking Act, because I do want us to have a little bit of time to go into the details of the FDIA.
Very quickly, what happens in those proceedings is either the New York Department of Financial Services or the FDIC will seize all of the assets of the bank, not just the branch, in the United States or in New York, and use those assets to satisfy the obligations of the branch's creditors. That is quite nice for branch creditors, because banks often have a lot of assets in New York or the United States. And so it can work out very well, although it creates a weird interplay with the bank's home office.
Okay, so let's talk a little bit about the actual FDIA proceedings. And I think we've talked a little bit about the introductory slides already, and the different strategies, which you already mentioned, Brandon. So I'm going to go ahead and focus on some of the particular issues that people face, like, what happens to cash and what happens to other types of assets, if that's okay.
Sure. So Cash is technically insured only up to $250,000. That is a per depositor per ownership category, not a per account category basis. So do not think, oh, I hit 249, I'll just open another account, title it the same thing, and you'll be okay. It's the amount is assessed on a per depositor basis. As a practical matter, that's the legal limit. As a practical matter, the FDIC will frequently, not always, don't bank on it, will frequently transfer both insured and uninsured depositors to an acquirer or to a bridge institution, as we saw with SVB. So there is it's often the case that even uninsured depositors will get full recovery, face minimal disruption, but you cannot rely on that. There is the possibility of loss. And so one possible way to limit your loss is to use something called a sweep program. Now, what a sweep program does is it says, okay, I have $500,000 in this account at a bank. The bank has agreed that to the extent there are amounts in that account over 250, they will transfer those amounts to some other location. That other location could be an account of a money market mutual fund at the bank. And when the cash gets transferred to that money market mutual fund, the money market mutual fund will issue the bank shares. And so now I've gone from having cash of 500,000 to cash of 250,000, fully insured, and $250,000 worth of money market mutual fund shares. When the bank holds those shares, that they are holding those shares in a custodial capacity. What that means is that I should not incur losses on those shares on account of the credit risk of the bank. I could incur losses if they are fraudulently converting those shares or if they're not holding them for whatever reason, but I'm not exposed to the bank's credit risk on account of them. This sounds like a wonderful solution, and it is, but you also bear in mind that when that happens, I've now invested in these money market mutual fund shares. And as a result, those shares could go up in value, they could go down in value, they could do something called break the buck, which means that they face themselves their own little run. And I could incur significant losses on those in a way that happened in 2008 before the Federal Reserve essentially stepped in to protect the entire industry. So if you are thinking about a sweep program and how wonderful it is, you need to look at the details. I don't want to, I know we're a little pressed for time, so I don't want to get too deep into it, but internal sweeps treated differently from external sweeps, treated differently from same-day sweeps, treated differently from overnight sweeps, and you could have sweeps into securities, sweeps into repos, all sorts of different types. So you really need to look at the individual documentation and the FDIC's rules and see how your sweep program will actually be treated in that situation.
So I'm going to skip over the margin for uncleared swaps, although you should read about that because obviously we're going through the things that Dodd-Frank put into place, and you want to make sure that all this margin you're exchanging to keep the industry safe isn't at risk, and how it's held. But I think we should move on to the famous QFCs that we also mentioned at the outset, and why do we care, and why are they special, and how do they work, and what do you need to worry about?
So QFCs are most relevant for counterparty risk, not custodial risk. And essentially what a QFC is it's a special type of trade that is given special type of protections in the event of insolvency. And the protections actually apply in all of the regimes that we've talked about: Bankruptcy Code, FDIA, New York banking law, International Banking Act through a weird provision of fiducia. Those protections always apply. And what they basically do is they say, notwithstanding this automatic stay, notwithstanding the SIPC stay, notwithstanding all these other limitations on creditors' rights, what we colloquially refer to as the parade of horribles, in the event proceedings commence, if you have one of these special types of trades, a swap, repo, securities contract, you can terminate that trade. You can take your collateral, liquidate it, sell it, get the proceeds. You can net amounts owing. You can recover. You don't have to worry about this regime in large measure. That is a relief for creditors, but also a significant hindrance to the ability to resolve the institution. As Sachiyo mentioned, in 2008, when Lehman went under, there were a lot of closeouts, and there are good arguments that that is one of the things that exacerbated the systemic risk. And so some of these regimes impose minor and temporary limits on the ability to exercise these, quote, safe harbor rights. In particular, under the Federal Deposit Insurance Act, there's what's called a 1 business day stay, which says that if the institution goes under on a Friday in the middle of the day, the FDIC has until 5:00 p.m. Eastern time, regardless of where the bank is organized, it's always Eastern time, to transfer the QFCs to another institution. If they don't transfer and the stay expires at 5 p.m., you can go ahead and close out. If they do transfer, you've now welcomed into your institution whoever the transferee is, and they're your brand new counterparty with whom you get to trade. The FDIC can also just decide to repudiate those trades, which is essentially equivalent to letting the stay expire, more or less. But those are your options in an FDIA proceeding with respect to this.
So I want to pause here briefly because obviously these are important contracts, huge volumes, and we're relying on these rights that Brandon talked about. So what are some of the most important considerations that you two think about in practice when you're looking at those contracts and the risk?
Yeah, so as I mentioned at the outset, it's really about making sure you have one, that you do have a QFC and you haven't done something to the terms of your trade such that you've put that contract outside of the QFC definition. And also just understanding the different stays. I mean, we've talked about the FDIC or the FDIA stay, the OLA stay. There are stays around the globe, the 2-day stays under the BRD regime. And most of the time when you're thinking about a potential dealer insolvency, you're talking about the entire group. And so you need to understand sort of all of the different international regimes and how they apply, how you've agreed through contract to turn off your cross default rights, your rights to terminate, and also how they've been turned off by statute. So I would say those are sort of the main considerations.
Yeah, I would agree with that. The other thing I would add is, especially if you've got a large, complex potential insolvency, you really need direct lines of communication into the relevant regulator that may be winding down or circling the institution. You cannot assume that all relevant information you need around whether contracts have been accepted or not, when stays are or not over, is going to be publicly available. So having a direct line of communication through your counsel or directly into an entity like the FDIC is quite valuable.
So I want to make sure that we have time to get to the practical tips. Sachiyo and Angie, are you around? Can we do 5 minutes beyond? Okay, great. So I will just touch briefly on credit default swaps because they are sort of the media darling. And every time something goes wrong in the financial industry, we talk about credit default swaps, which is their purpose because they are swaps that are triggered by the default of another entity that underlies them. So they are generally QFCs. They are swaps, they're derivatives. Some of them are cleared, some of them are not. But in essence, a credit derivative is a form of credit insurance whereby you have a protection seller that agrees to make the credit protection buyer whole for a deterioration in the value of certain debt obligations of a reference entity. And the current value of those debt obligations is generally determined by reference to an auction of a subset of those debt obligations. So at a high level, what you have is, in order for all of this to work, you have a trigger event. It's called a credit event. When that event happens, that event has to happen in relation to either the entity that you have bought or sold credit protection on. It's called the reference entity. And that would be sort of a bankruptcy, for example, that happens to the entity. But in general, you're looking at these events, be it a failure to pay, a restructuring happening to a certain defined set of obligations of that reference entity. And when that happens, then you move into the next phase, which is you basically run an auction to determine how much the credit protection seller has to pay the credit protection buyer. This product is a lawyer's dream, not just because it all started when I started practicing law, it was very exciting, but also because the event that triggers this payout isn't a number on a screen, it's whether or not some sort of event has happened that satisfies the word on a page. So this is why we're called upon to determine that. It also makes this a very tricky product. Lots of issues have arisen as to whether these events have occurred and also whether or not it's the type of obligation that meets the obligation characteristics that this event happens to. Because you can imagine the credit protection seller isn't so keen on the event happening, isn't so keen on the obligation being one to which the thing can happen. And also they're going to be very concerned about the type of deliverable obligation that's going to be valued to determine that value difference.
So from a just a current event perspective, the topic of credit defaults and exactly the analysis that CDS analysis that Deborah went through was quite relevant over the last few weeks with respect to the write down of Credit Suisse's AT1 bonds. And the key part of the analysis that Deborah just referenced is, was there a standard reference obligation that was impacted that would trigger CDS? And those AT1 bonds were not the standard reference obligations in connection with Credit Suisse CDS. And so by and large, from a standard perspective, those were not triggered.
So the one thing I would say is that the 2014 credit derivatives definition, so back in the day, happily when I started practicing law, we had this long form, then we had one version, then we had another version, then we have lots of supplements to these things. But the 2014 version of the credit derivatives definitions were actually created, to Angie's point, for some of the events that happen in the financial crisis, in particular to European financial institutions. So this really was sort of the type of thing that these definitions were catered for. And by and large, you know, depending on which side you're on, you might say that they worked the way they should, although there were some, you know, housekeeping issues, shall we say, around perhaps the standard reference obligation point, for example. So moving on to, I think we talked about Silicon Valley Bank and Standard and Signature Bank as part of your discussion of the FDA, but I do want you to be able to draw out anything in particular before we move to the practical tips section.
I think I would just note one thing, which is that there's been a lot of attention based on the interest rate risk that SVB was exposed to. And I don't mean to discount that, but I don't think we've yet seen conclusive evidence that actually that rendered it insolvent. Rather, what rendered the institution insolvent is the run. And essentially what happened was everyone was like, oh no, this is other people might run, so I need to run too. It's very rational and the right thing to do, but it's also the thing that can bring down a fully solvent institution, which raises a massive policy issue for people to think about.
Was that a deliberate pun, discounting interest rate rates?
Oh yeah.
I think Don has a question.
Dawn, oh no.
No, I think that's right, and why there's been a push to increase the FDIC insurance limit to kind of prevent runs from occurring going forward. And it'll be interesting to see how high they push that limit, whether there is any limit in the future at all going forward.
Yeah, but confidence is everything for financial institutions. And, you know, when you've got a Twitter-led bank run, it's really a problem.
So before we move on to sort of general tips that you have for people in your position that are looking at sort of bank distress, what was your sort of experience generally with the Silicon Valley Bank and the Signature Bank situations? You know, what are you going to sort of take? What's your sort of biggest takeaway from that?
I guess I'll start. I mean, you know, my takeaway personally, and I think for my team, and we cover all of the trading relationships at BlackRock, it's just kind of back to basics. You know the insolvency regimes, have your documents to hand, know the terms in them, you know, things like downgrade triggers. To Angie's point earlier about there are early warning signs that you have to be on the lookout for. You have to look out for them and you have to know what it means for your documents. And just being very facile with all of that so that you can react quickly as events unfold.
Yeah, I would also add onto that and agree with all that. Secure counsel early. Often in these types of situations, there is a contagion risk. And so you want to lock up counsel that you trust, whether it's Brandon or Deborah or whoever else is in your Rolodex early, because everybody's going to be calling them. Secondly, know exactly who your counterparty is, where you have your exposures, because you may have documentation in place with multiple entities of this organization around the globe, but you may have all of your major exposures in their German sub or in their California non-bank entities. So know exactly where your key exposures are. And then also get those default management processes and protocols in place, activate them early because of that whole contagion risk.
So from a documentation perspective, is there anything that that sort of came up this time around that you didn't see last time around, or any particular types of provisions that were good or problematic, or that that sort of is a takeaway on the documentation side?
Last time I was in the middle, so you shouldn't ask me.
Yeah, I mean, I think on the documentation side, for me, one thing I would say is a lot of this does include, not just this, as MRAs include essentially an automatic early termination provision that says if the counterparty hits insolvency, then there's an automatic termination of the transactions. The problem with that is that there could be a stay of that automaticity, and then you have to figure out how does the end of that stay interplay with the automatic termination. And that can be super relevant, not only for figuring out if there's been a termination at all, but valuing the trades following the termination. So just being very mindful about that provision and making sure you're not inadvertently including it in a way that can be detrimental to valuation and others.
So I think that brings us to the end of our session. I want to thank my amazing panelists, but before you go, is there anything else? Because I know I rushed you through a few of these sections, and I know you have so many valuable things that you can share. Is there anything, any last pearls of wisdom you want to leave our audience with?
We talked about, we're obviously lawyers, a lot of lawyers in this room. But when something is going down, you need to also think about operational type issues. So it's not just knowing what's in your documents, getting your notices ready, but figuring out when do you have to get those served by? Exactly when would a default happen? When do the Fed wires close? How am I going to get my money? When is my money going to come? Can I shut down a movement of money outside of my institution as soon as something's going down? Can I talk to my collateral people? Can I talk to my settlements people? There's a whole layer that goes beyond just what's in the docs and really requires communication and coordination with a whole host of people inside your firms.
Yeah, agreed. And you're absolutely right. It's the lawyers, it's the entire infrastructure team, credit, operations, the heads of the business, all need to be in close contact, and you need to be ready to serve them with the legal advice.
Great. Well, thank you very much. It's been a real honor and a privilege, and I will hand it over to Marisol to close us out.
Let me thank you all again. It was fantastic education. Appreciate it. Round of applause. I'll just note, having been at DTCC, reading those AT1 bonds ahead of the trading would have been very helpful too. I think it was a real surprise for a lot in the industry in terms of the write down of those bonds. So it's an interesting study for sure. Any questions for our panel? We've got a minute or two before Ron and our CFTC chair, Benham, comes and join us. So yeah, we have an eager question here.
Hi. So the charity that I run had all its money in Signature Bank, and it was way over the $250,000. So we were very pleased that the Fed stepped in and the things worked out well. On the other hand, there's a lot of talk about moral hazard always in the media, and there has been since 2008. And what do you think about that? And do you think that the deregulating the kind of regional banks from the Dodd-Frank era a little bit contributed to this crisis?
So I'm going to let someone smarter than me answer the moral hazard, but I will tell you, I do a lot of work on nonprofits, and I always end up sitting on the finance and audit committee for some reason. We spend a lot of time making sure that we have diversified our finances. And so to the point that we have, 245,000 and under accounts and CDs, and we recently diversified on one of the nonprofits I'm in into T-bills. well before this happening because of concerns around these risks. So I can't speak to moral hazard, but I can tell you, I spent a lot of time with my nonprofit hat, thinking about these risks and trying to manage them effectively.
Brandon, you're on with the moral hazard.
I would not in any way assert that I could in any way be smarter than Angie. So I didn't think that was directed to me. But on the moral hazard point, I think as a practical matter, in many cases, these deposits are effectively get insured. It's just random whether it happens or not. And whether you run or not is not typically going to be based on the credit risk of the counterpart. It's based on whether other people run or not. So personally, I don't think that declining to insure deposits really facilitates a limit on moral hazard. I think the way to limit moral hazard is to actually just have no, this is a personal view, not Cleary Gottlieb, have no cap on insurance, and then just make sure it's paid for, in the sense that depositors, the banks, pay for full insurance at kind of unlimited level.
So even if Brandon's smarter than everybody else about what should happen, as someone with fiduciary duties for nonprofits, I would not go over 250.
Never.
Okay, last round. Okay.
Okay, so just a question, I'm wondering if it's under any consideration. You referred to single point of entry strategies never being tested. So it pulls my mind back to the days where SIFMA would do the Reg SCI testing, and they also do Quantum Dawn. Is there any way that folks can imagine doing some sort of like simulation for something like that, where we could sort of get a feel for where the gaps might be ahead of time?
I think it's hard to say, because the viability, you can put so many pieces in place, you can test them. Whether SPOE works or not is whether the write down of the debt, the recapitalization of the institution preserves confidence in the institution, right? If people are comfortable continuing to trade, if people are comfortable leaving their assets, leaving their securities at the institution, it will work. And you don't really know, you can't really predict that. That depends on what actually happens. I don't think people predicted, to Don's point about kind of the Twitter and to Sachiyo's point about the Twitter risk, I don't think people predicted that a loss and then an announcement of a capital investment would cause a massive run at what had generally been a well-run or well-established banking institution. So it's a little hard to predict what would actually happen in an attempt to effectuate a single point of entry strategy.
That being said, I do think College of Supervisors for major institutions do spend time thinking about these issues.
And people do run distress scenarios in their financial institution. So this does get tested, but I think it's always the case of how is it going to work in practice. And my own personal view, having spent all those nights that Sachiyo talked about back in 2007, 2008, really, my own view is still that it's got to be better to have the infrastructure, the plans in place than not. So I think we probably have come to the end of our time. And thank you again.
Thank you, everyone.